Hello, my name is Caden. This is Castle Tutelage, your home defense network. This next topic is going to be legal use of deadly force. I am not an attorney. I am not a lawyer. I am not a bottom-dwelling lawyer who resides in the muds in the depths of the earth. I am not that person. This is for information only. Do not use this video as legal advice. Do not use this video as legal advice. Information only. Do I need to say that again? Information only, not legal advice. Now, for you stand your ground states, this law does not apply to you. This tactic really doesn't apply to you. But you should know in the back of your mind, you should think about exactly what other states really go to. Because if you do have the stand your ground state, but you use what I'm about to tell you, it'll help you even more than standing your ground. You wronged me. No. We're just dealing with macro ideas, not micro ideas, okay? The verbiage is kind of similar in other states, and I'm just going to be reading right out of the book, okay? This is for Minnesota, and the section, it could be different. It will be different in your state, but the verbiage is basically going to be about the same if you are not a standing ground state. Section 609065, justful taking a life. The intentional taking a life of another is not authorized in Section 60906, except when necessary in resisting or preventing an offense which the actor reasonably believes exposure to the actor or another to great bodily harm or death, or preventing the commission of a violent felony in the actor's place of abode. I love that sentence. I won't get into the subsection of that, but we'll just get into what I was originally talking about. Subsection 8, great bodily harm. Great bodily harm means bodily injury which creates a high probability of death, or which causes serious permanent disfigurement, or causes a permanent of protracted loss of impairment of the function of any bodily member or organ, or another serious bodily harm. Okay. Those are basically pretty much similar from state to state. Now, what we're going to be getting into is the 4 pillars of a required retreat state, like what Minnesota is. Again, for people who badmouth California and its practical application of the law, Minnesota is so much more draconian in nature, where people will badmouth California, but they will not talk about states like Minnesota and application of their law. The 4 pillars of governing the use of deadly force: reasonably and intimate fear of death and great bodily harm. So you need to have these 4. You can't have 3 out of the 4. You can't have 2 of the 4. You can't have these 2, those 2, these 2, that 2 of the 4. You can't have 1 of the 4. You can't have 3 of the 4. You have to have all 4 requirements for a justified homicide in the state of Minnesota, or any state that does not have standing ground. Okay, the 4 pillars governing the use of deadly force. First one again: reasonably and intimate fear of death and great bodily harm. The second one is you have to be a reluctant participant. That is, no, don't hurt me. I'm afraid that you'll kill me. That kind of scenario. You have to be reluctant. You cannot be an active participant in escalating any section of it. You can't escalate, de-escalate, walk away, and then have to defend yourself. You have to be legally on the de-escalation climb of the entire thing. Again, I've talked to you about that one scenario where a guy talked about a CCW scenario. He was driving his car. Someone was coming from the other end, giving a bunch of gang signs as he drove by. The guy swung around, went to a fast food, got out of his car, escalated, walked to the fast food place. The other car came up to him and started talking to him. Guy turns around, escalate, walks to the car, escalate. Okay? You cannot escalate anything. You need to be on the downward slide of it. No reasonable means of retreat. Being able to run away is going to be more important. But again, if the guy has a gun and you cannot egress with ease, well, it is what it is. You need to have an out. You need to be like when we're doing with defending a choke point in the home, a static point. You need to retreat as much as possible. That is the state. Again, California and Minnesota, two different worlds. People badmouth California, but when you have states like Minnesota, no one says anything. The fourth pillar is no lesser force will do, where if the perfect example is that I am a 6 foot fat guy. I am 6 foot tall, 280 pounds. If a 90 pound, 4 foot, 10-inch woman starts attacking me with her hands, well, I can't just go boom. All right. No, the law in this state will never allow that to happen. Now, if I was in a wheelchair, well, maybe that is going to be a different level of scenario. Now, let's just say that a 5'10" or a 4'10" woman, 90 pounds, came after me with a baseball bat. Does that come to the level of, I don't know. You know, I don't know how the prosecutor, the judge, the jury is going to really realize that. And there is no definitive cutoff saying, yes, that will apply as if a 4'10", well, let's do it a different way. A 4'10", 90 pound, 80 pound woman on bath salts with a baseball bat coming after me. Can I use deadly force at the time? Do I have access to a bat? You know, those are going to be a lot of questions where you are not going to get a black and white answer unless you really think it through and be really proactive in that decision. Okay. Now you're going to ask yourself, 3, 2, 1. Where do they apply? You're going to ask yourself. Generally speaking, every state in the union allows the use of deadly force to defend oneself when threatened with death or great bodily harm. The 4 rules that apply in Minnesota may or may not apply in the other states. Defending yourself and others. These same conditions apply to defending another. Okay? So, again, with the state of Minnesota, if you do not know the person that you're coming to the aid and you have a weapon, the state of Minnesota requires you to back off. Get on the phone, get out of the area, not even be a good witness. It seems like the state of Minnesota doesn't even want you to be a good witness. That is, if you have a permit, they want you to skedaddle, get away. Now, reasonably in immediate fear of death or great bodily harm, what it means. The threat must be immediate. A verbal threat to injure you, like if a guy is on the third balcony and says, "Boy, I'm going to rip your nose out from your butthole." Well, he has to have access to you. There has to be some kind of immediate threat. Distance isn't where it is. Just the same thing as if a guy had a baseball bat and he was 60 yards away, is that immediate threat? No. You can retreat at that time. That is something that you need to also take a look at. Great bodily harm in a legal measure that implies injury so great that death is likely to or possible, or that you'll be disfigured, crippled, or permanently or for a sufficiently period of time. In the 70s, there was people walking around New York City throwing acid on people. That is great bodily disfigurement. That would probably rise to the level of immediate fear or death of great bodily harm. Okay, the condition of the victim matters. For example, in most cases, if a smaller man, again we talked about this, if a smaller man is punching a larger man in the chest, would it not be considered great bodily harm? However, sorry about the phone. I'm not going to be doing this over. It's going to ring a couple more times before the answer machine picks up. However, if the larger man had a serious heart condition, the criteria may be met, even though the attacker had no knowledge of his condition. So again, even if we did the scenario of the wheelchair. If you know, a person that was being attacked that had cerebral palsy, I guess that would be that notice. But we'll just go with their heart condition. So if you have a heart condition and a smaller man comes up and starts attacking you, yes, reasonably or in immediate fear of death and great bodily harm, that would rise up to the occasion. Reluctant participant, what it means. You cannot voluntarily enter into a confrontation. For example, if you're voluntarily entering an argument that escalates, it will not matter if you have met the other criteria. Again, you cannot escalate. You cannot confront. You need to say, yes, sir, I am a douchebag. Go on. Yes, sir, I do suck dick in the gutter for beer money, but again, that's only until I get my self-respect back and get out now. No reasonable means of retreat. What it means, are you expected to retreat from a dangerous situation? The obligation to retreat never ends. For example, if you are able to wound the attacker such that it opens up an opportunity to retreat safely, you must retreat. And we're just going to talk a little bit about no lesser force would deal. What it means. If you can stop a threat with something less than deadly force, you are required to do so. You are required to stop using force as soon as that threat stops. For example, if 3 bullets stops an attack, the 4th bullet is a crime, okay? How are you going to be determining that? I'm not exactly sure. The condition of the victim and the attacker matters. For example, a 200-pound man being attacked by an unarmed 100-pound woman has lesser force alternatives rather than resorting to deadly force. In the reverse scenario, the smaller woman may have no alternative other than to immediately resorting to deadly force. Okay, what does that mean? You are not required to try other methods before using deadly force. You are simply expected to consider other alternatives and to only use deadly force when no other lesser force option is sufficient. This is great information whether you are a stand your ground state, whether you're a castle doctrine state. If you go by these principles, especially if you are in a stand your ground state, is going to make yourself not look like that Zimmerman character, okay? Steve Zimmerman, okay? If you do what the state of Minnesota asks you to do, it's going to fall on a higher level, a higher responsibility for your specific situation. Okay? I hope this helped. My name is Caden, Castle Tutelage. Let me know what you think.